All right. Hi, everybody. This is a training sponsored by the MMCRC, the Manufactured Marina Communities Resource Center. OSTA is also a partner of the Oregon State Tenants Association. They help us get out the word for these trainings, send out the links, and get those published. I am an attorney. I work with the Oregon Law Center. I have a special grant that allows me to work solely on manufactured home parks and floating home marinas, and OHCS, so MMCRC, aka the state of Oregon, holds that grant, and they have asked me to present on various topics regarding what we call the back end of landlord-tenant law. Basically, here we're going to be talking about abandoned property and storage agreements in regards to that back end of Chapter 90. So people who live in manufactured home parks and floating home marinas and own their own home, but rent the space that their home is on. All right. So the agenda for today, we'll go through a brief introduction. Then we'll be talking about the right to possession versus the right to sell. These are separate rights, and you hold these rights at different times. It's important to understand the difference between these two rights when we're talking about abandoned property and storage agreements, because you don't have both rights under a storage agreement. Then we're going to be talking about abandoned property in detail. I'll warn you ahead of time, this statute is a bit complicated. I've done my best to break it down into digestible chunks, but there are a lot of caveats in this law, and so this presentation is not going to go over every single caveat. If you are in a situation where you feel like you need help with an abandoned property or a storage agreement situation, and your questions are not answered here today by the general overview of these statutes, I highly recommend that you apply for services at your local legal aid office. If you are over income for that local legal aid office, then maybe reach out to MMCRC. I am accepting limited referrals at this time through MMCRC as we kind of adjust to my new role in getting to hold these trainings and do more tenant outreach as well. We're trying to adjust that caseload. So, but again, general information, not going to cover every single situation regarding abandoned property or storage agreements. If you particularly have a legal issue in this area, please have an attorney look at that. This is not going to be the end all be all of what your situation may entitle, right? After we talk about abandoned property, we're going to go into storage agreements, the right to a storage agreement, what storage agreements can entail, and what rights you have under a storage agreement. Then we'll have some time for Q&A, and I will do my best to answer any questions that you guys may have. If during the presentation you have questions or feel confused over a section, please feel free to pop it into the chat or raise your hand. I'm not sure that I will be able to see you while I'm in presenter mode, but please feel free to, but if I could ask Ken, if you could keep an eye on the chat and just make sure that if anyone raises their hand, we just pop in, interrupt me, and we can answer that question, deal with it while we're in that area of the law.
Sure.
Thank you, Ken. All right, so I briefly explained this at the beginning. Excuse me, I'm so sorry. I have had a runny nose for months. All right. So I briefly explained who I am and where I work at the beginning, but I'll go into a little bit more detail here. So again, my name is Samantha Sheehan. I am a double duck. I graduated from the University of Oregon Law School in 2020. I first started as a clerk at the Lane County Circuit Court, working for the now presiding judge, Jay McAlpin. And after that, I moved to the Oregon Law Center, which is more commonly known as legal aid across the state. There are two legal aid organizations in Oregon. That's Oregon Law Center and Legal Aid Services of Oregon. We have different funding sources, which is why we're different organizations. but we were sister organizations. We work together, and between the two of our organizations, we serve every single county in the state of Oregon. I am based at the Eugene office, the Lane County office of the Oregon Law Center. However, my position is statewide. When I first started at Oregon Law Center, I started at the Eviction Defense Project, again, doing statewide representation of tenants, but solely in eviction cases. That means that the landlord had issued a termination notice, that termination notice had expired, and that landlord had filed that termination notice with the court, and the tenant was in actual eviction court. In June of 2022, I transitioned into this position, where I am representing facility tenants. So those of you who own your manufactured home and live in a manufactured home park, or own your floating home and live in a floating home marina. Excuse me. My financial eligibility is significantly higher than that of general legal aid. So as I mentioned before, if you apply for services at your local legal aid office and you are denied based on financial eligibility, that does not mean that you're completely out of luck. Although I am only one person for the entire state of Oregon, like I said, I do have a higher financial eligibility, and I have a little bit more flexibility with what types of cases that I can take. So it's always worth it to give it a shot. We can never guarantee services. Obviously, we're legal aid. We are, an underfunded, understaffed organization, but we do our best to serve everyone and provide people with advice who walk through the door at the very least. So, give it a try, apply for local legal aid. If that doesn't work, please feel free to apply for my services, and we'll do our best to assist you. As I mentioned, I'm funded through a special grant. That grant is actually funded by all of you tenants through the special assessment that you pay in your property taxes. It's $10 a year. That goes into a special account that funds the MMCRC and as well as my grant position. This presentation applies only to facility tenancies. So like I mentioned before, we're talking about the back half of Chapter 90. Chapter 90 is the Oregon Residential Landlord Tenant Act. The front end of that is the main portion of landlord tenant law. It applies to those people who rent an apartment, rent a house, right? They're renting both the physical space where the house is located, as well as the brick and mortar, if you will. Whereas in a facility tenancy, you are only renting that space, that location where the home is located. You own the brick and mortar, so to speak. The front half of Chapter 90 does in some cases apply to facility tenancies. However, the back half does not apply to apartment tenancies. This does make reading the law a bit tricky, because just because it says one thing in the back end doesn't mean that there isn't more to that law located in the front end as well. This is why it is important to get legal advice when you can, particularly if your landlord disagrees about your reading of the law. It's not easy to just pick one statute and be able to, fully understand the repercussions of that law, because statutes aren't taken just in isolation. They're taken in context with the whole chapter, and other laws do affect those single statutes as well. So it is it's important to have someone who's well versed in being able to read the law and interpret the law, take a look at your case if there's a disagreement about what law applies. A huge caveat here: this is not legal advice. I cannot provide anyone here with legal advice. Legal advice is essentially applying the law to the facts of your specific issue, which means if you say, my landlord is doing X, Y, and Z, what should I do? I cannot answer that question, because that would be legal advice. If you ask me, my landlord did X, Y, and Z, is that illegal? Again, that's legal advice, and I cannot answer that question. What I can do is provide you with general legal information. So you can ask me, say, Does the law require that a landlord do X, Y, or Z? Or if a landlord did X, Y, or Z, what does the law state should occur, right? What occurs when the landlord violates this statute, right? Things like that. So something that does not require me to look at the facts of your issue and apply them to the law, but some questions that are based around really what the law says and what the law requires. Those I can answer, and I'm happy to do so. Again, if you need legal advice, please reach out to your local legal aid office to conduct that intake. And again, if you are rejected for financial eligibility, don't fret, there are other options. That other option is me, and you can contact either MMCRC for a referral, or you can reach out to my local legal aid office, which is the Lane County office. With the caveat warning that right now I'm not taking cases that come through my intake office. I am only taking a limited amount of MMCRC referrals. Again, this is just during the meantime while we attempt to kind of get things settled with some of these new activities that are included in the grant. All right, so let's get into the meat and potatoes here. Let me take a drink before. All right. So to kick us all off, we're going to just talk about the difference between the right to possession and the right to sell or remove your property. These, again, are different rights. When we talk about property rights, in law school, we discussed the idea of the bundle of rights. I really love this idea. I'm a visual learner, and so if you want to think about property rights as a bunch of sticks, right? These sticks can all be put into a bundle, and that bundle can be handed over to another person, or those sticks can be individual, and you can hand only some of those sticks over to another person. This means that you have multiple property rights, and those property rights are divisible. So it's not required that if you have one of these rights that you have another, right? You can give one or more of these rights to another person. So understanding that these rights are separate rights, they're individual, and they are not dependent on one another, right? One can exist without the other. The right to possession and the right to sell are two of those many property rights. So these are two sticks in that big bundle of different property rights. You will hold these sticks, these rights, at different times in your tenancy. When you are a tenant, a facility tenant, you have a written rental agreement with your landlord, you pay space rent, you own your home, you have the right to possession. That rental agreement gives you the right to possession. That is the right that is being conferred upon you, right, when you sign that rental agreement. So when you sign that rental agreement, the landlord is giving you one of their sticks for their land, because they own the land that the park sits on. When you sign that rental agreement, you are getting the right to possession, that stick from the landlord that allows you to possess their property. You have the right of sole possession to that rented space, meaning your landlord can't just come on your space and whenever they want. They can't come into your home, right? They have to provide you notice and a reason to come onto your rented space, because you solely hold that stick to the right of possession. The landlord has given you that stick when you sign that rental agreement, and that is yours to hold. While you are a tenant, you also hold the right to sell. The right to sell here is attached to your home. It's attached to your property. You don't have the right to sell the rented space, right? But you do have the right to sell your home. The right to sell your home stays with you. It stays with the owner. So even if you, for example, are not a tenant and do not have the right to possess, because you say have a subleasing agreement, so someone other than the owner is living in the home and they are paying the rent, and they hold that stick, that right to possession, you would still hold the right to sell as the owner of that home. So even though you don't have the right to possession in that circumstance, you do have the right to sell. So at different times and in different circumstances, you may be holding both sticks, the right to possession and the right to sell, or you may be holding only one stick, the right to sell. Again, yes, this is the right to live in and access your home, and it's sole possession, so basically the right to exclude others from the home and the rented space. The right to sell here is the right to transfer to another owner, right? Easy peasy. You also, under this right to sell, have the right to either dispose of or, move your property, right? So when we're talking about the right to sell, you can also think of in your mind, that's also the right to remove your property from the park. Again, this is an independent right. You retain this right even if you're not a tenant anymore. Upon the termination of tenancy, you will lose your right to possess the home and possess the rented space, but you will maintain the right to sell the home or remove the home from the park. All right, so now we're getting into the really fun, complicated stuff. What is abandoned property? And just context, please keep those two separate rights in your head as we go through this. It's important that you understand the difference between those rights, and how those rights are affected by the following things, right? So those rights are affected by the abandoned property process and by storage agreements. So understanding that they're separate, independent rights is super important context for the rest of this presentation. All right, so what is abandoned property, you ask? Well, abandoned property is a home that is left on the rented space after one of the following three things happens. One, your rental agreement has ended either by termination, meaning you got a termination notice, and your rental agreement was terminated under that notice, or your rental agreement has expired, meaning you had a fixed term rental agreement and it came to the end of that rental agreement and your landlord had told you before the end of that rental agreement that they do not want to renew your rental agreement, then your tenancy has ended in that situation. It is an important caveat to note that generally speaking, a fixed term lease or fixed term rental agreement will renew as a month-to-month automatically. So if your landlord does not provide you with the notice that they're not going to renew your rental agreement or notice or provide you with a new rental agreement to sign in accordance with the law, then your rental agreement will just turn into a month-to-month rental agreement. So when we say the expiration of your rental agreement, please just note that there are some caveats to that, right? That doesn't just mean that at the end of your fixed term, you have to move out. That's really not the case. Only if your landlord does certain things would you have to move out at the end of a fixed term rental agreement. This abandoned property also applies if you've left your home on the rented space after you moved out. This could be you just left without telling them, you had an agreement to move out, whatever it is, right? So basically, you've moved out and your landlord reasonably believes that you've left the home and you have no intention of reclaiming it or coming back as a tenant. In that circumstance, basically your landlord can say, okay, well, constructively, this tenant has terminated their rental agreement by moving out and having no intention of returning, right? The second circumstance is if you have been absent from the home. So if you've left the home and you've been gone for 7 days in a row after the termination of tenancy by a court order, right? So an eviction judgment was either entered against you, or a stipulated agreement was entered against you, or entered in your case, that requires you to move out by a certain date. So long as there's a court order that requires move out, and you've moved out before the sheriff was ordered to remove you. So in an eviction case, there are a few steps. The eviction judgment itself does not, isn't really, isn't going to do much, right? You have to get what is called a writ of execution. That writ of execution is issued by the court and given to the sheriffs. Then that writ of execution is what orders the sheriffs to perform the removal and the lockout. So the second circumstance is after you've been in court for an eviction, but before a writ of execution was entered, right? So basically that you complied with whatever you guys agreed to, or you complied with the move out, and the landlord wasn't required to request that writ of execution from the court to get you to move out. The third circumstance is where the landlord did have to request that writ of execution and get the sheriff's assistance to remove you from the property. In this case, I believe that, the way that the statute is worded, that it is really about the writ of execution being issued, and the sheriffs, so that order that the sheriffs remove you, that's really the triggering event. So if your landlord gets that writ of execution against you, but you move out 15 minutes before the sheriffs show up to post that 72-hour notice on your door, I think you would still fall under this third category, because the court had already issued the sheriff to remove you. So essentially what we're talking about is you've moved out. You've either moved out because your rental agreement was terminated outside of court by yourself, by your landlord. Your rental agreement expired and your landlord either gave you a new rental agreement to sign that you unreasonably rejected, or your landlord expressed intention to not renew your rental agreement with enough notice. Or you just moved out while not saying anything, and your landlord believes that you're not coming back, right? So that you really just have abandoned the property. Or you went to court and you either moved out on your own, or you moved out after the sheriff was ordered to remove you. So we're talking about a time where you're gone. You're no longer in the home. You no longer have the right to possession, right? Because the right to possession is attached to your rental agreement. In these circumstances, your rental agreement has been terminated, either because you moved out, either because you terminated it, your landlord terminated it, or you were evicted, right? So at this point, there's no rental agreement. That means you do not have the right to possession. However, you do still hold that right to sell or remove your property from the rented space. So we're talking about homes that you can't go into anymore, and what the landlord has to do in that circumstance. Just a note here, the personal property that's left inside of your home or on the rented space. So say you left a wheelbarrow and shovels outside, and you left furniture and clothes inside the home. Those are still considered abandoned property, but they're governed by a different statute. And so here kind of comes that confusing narrative where the front end also applies sometimes to facility tenancies. This is one of those cases where the personal property that's inside the home, so basically anything other than your home itself, right, or the structures that have been built on the home, on the space, anything that other than that. So really the kind of things that you would think of traditionally as personal property, cars, clothes, furniture, all that kinds of things. They are protected, and there is a process that your landlord must follow regarding those items. But again, that process is governed by a whole different statute. That statute is found in the front end of landlord-tenant law, and we're not going to be discussing that in this presentation. This presentation is really about preserving your right to sell the home and understanding what rights and obligations you have after you've moved out of the home, but the home still exists on the rented space. So now we understand what abandoned property is, right? It's your home left on the rented space after you no longer have a rental agreement and no longer have the right to possession. So what happens to that abandoned property? Well, your landlord is responsible for storing, selling, or disposing of your abandoned property. The landlord must follow the process set forth in 90.675(3) through 7 before they store, sell, or dispose of your abandoned property. This section 3 through 7, that whole area of the statute covers what is required for property to be conclusively considered abandoned. A property has to be conclusively considered abandoned before a landlord may take action to store, sell, or dispose of the property. So once it is, and we'll talk about those requirements of what your landlord must do before this occurs in just a moment. But what will happen to that property that's conclusively considered abandoned is that a landlord is allowed to either sell the home at a public or private sale, or they can destroy or dispose of the home. There are obviously caveats into this. So if they want to sell the home at a public or a private sale, they have to comply with the requirements that are found in 90.675(10)(a) and 11. And we'll talk about those in a minute. There is an option here that if there's no buyer at the sale, so if they hold a sale, it complies with the requirements, and there is no buyer at that sale, then the home will be considered, just presumptively considered, to be worth $8,000 or less. And as we'll see below, once the home is considered to be worth $8,000 or less, the landlord is entitled to destroy or dispose of the home under that second option, regardless of what the county assessors state the fair market value is. So the second option here, as I mentioned, is that a landlord can destroy or dispose of a home that is conclusively considered abandoned, but only if the landlord determines that the current market value of the home is $8,000 or less. The landlord must obtain that current market value figure from the county assessor. So they can't just make this up. They're not looking on Zillow. They do have to get that number directly from the county assessor. So those are the two things that can occur when your property has been conclusively considered abandoned. Your landlord has the chance to either sell it or destroy it or dispose of it. So here are some of the requirements that a landlord must meet before they may store, sell, or dispose of your home. So a landlord must give you, who is the tenant, right, or the prior tenant, because you now no longer have a rental agreement, right, but you were the tenant and have moved out. So they must give you a written abandoned property notice. They need to serve that to you, either personally deliver it to you or send it to you by first-class mail. They have to send this notice to all of these addresses, all of them. The home on the rented space, so the actual address where the actual manufactured home exists in the park. Any PO box that you hold and your landlord is aware of, right? So obviously if you hold 7 PO boxes, but your landlord has no reason to know of that and is not aware of them, they're not going to be able to send it to those PO boxes. So there is that requirement that your landlord be aware of these second 2 addresses, right? We can't require someone to do something that they have no reason to know about. So any PO box that you hold and your landlord is aware of, and the most recent forwarding address that your landlord is aware of. So that abandoned property notice needs to be sent, either given to you personally, right? So handed to you, the person, the tenant, or sent by first class mail to all 3 of those addresses. Again, 2 and 3 are only if your landlord is aware of those addresses, which is why you'll see the important note at the bottom that it's really important to provide your landlord with a forwarding address. This is important as well if you are an older tenant and you're the sole tenant of your home, right? And if you are to pass away and want your home to go to your heirs, you do need to provide an address, provide that information, provide that contact person to your landlord so that they know who to contact to send this type of a notice to, right? So again, super important. Have conversations with your landlord about where you're going to be. Make sure that your landlord knows how to contact you, and specifically has a physical mailing address that you have access to and regularly check. This is also important because if you've paid a security deposit, your landlord is required to do an accounting of that security deposit and return any remainder of that to you. If they don't know how to reach you, then they can't get that to you, right? So again, it's important that your landlord knows how to reach you and has a good physical address for you prior to moving out of the house, whether that's through an eviction, whether that's through a friendly and happy leaving of the park. Really, the circumstances are irrelevant. You really need to provide your landlord with a forwarding address before you move out. Even if you hate their guts and don't want to talk to them, it is in your best interest to do so, and failing to do so might put you in a situation where you're not receiving this notice, and then therefore you lose out on your chance to reclaim your property. All right, so landlord's got to give you, the tenant, that abandoned property notice. They also have to give that abandoned property notice to any lien holder, again, by personal delivery or first class mail. But if the landlord does first class mail, they also have to do certified mail with a return receipt requested. Lien holders, basically you're a lien holder if you own the home, either outright or jointly, but you didn't live in the home at the time that the home was abandoned, right? So if you are the tenant and the owner, you're going to be under number 1 because you're the tenant in this situation, right? If you were not living in the home at the time that it was abandoned, but you have a ownership stake in the home, and that's reflected on the title or on the home ownership document, that's going to make you a lien holder, and that's going to give you rights in this process as a lien holder rather than as a tenant. Those rights are different, so it's important to know the difference. If that abandoned property if a different tenant was living there, if you were not the one that was living there within a rental agreement at the time that home became abandoned, you're going to be working under that lien holder section, not the tenant section. And like I said, the rights are different, so it's important to know, what category you're in here, right? So again, if your home was used as collateral for a loan, then the creditor would also be a lien holder. So often you'll get, people get a mortgage, right? Or maybe get a home equity line of credit or an improvement line of credit, and they have used their home as collateral for that loan. What will occur is that the creditor will place a lien on the home for the amount of money that they have loaned you. And if you fail to, pay back that loan according to the terms of the loan, right, then the creditor, that the banker, whomever lent you the money, can execute their lien by forcing you to sell the house and getting the proceeds of the lien paid off in order to cover the amount of debt that you owe them, right? And so that's the point of being a lien holder. That is why these lien holders do have different rights under the law than a tenant would. So the landlord needs to send this notice to all the addresses that are actually known by the landlord for the lien holders that are of record. So when you're a lien holder, that's gonna be reflected on the home ownership document, and there should be an address listed on that home ownership document for any and all lien holders. And if the landlord was provided with a notice basically in the past 5 years from a lien holder that was provided to them by certified mail with return receipt requested, that essentially states, this is my, I have a lien on this house. The house is located at this address. If there's kind of a VIN number or a home ID number or anything like that that can help identify the home, that should be in there as well. But essentially, this notice wants to be as clear as possible about what, that you hold a lien on the home, what home it is, your contact information, and if you have the ownership document that lists yourself on it, then that's great to send in as well. The landlord is also required to give a copy of that written abandoned property notice to the county tax collector and the county assessor. So this all must be done before the landlord is allowed to store, sell, or dispose of your home. So at this point, your property is in the abandoned property process. So your home is in that process, but your home has not yet been conclusively considered abandoned, right? And remember that conclusively considered abandoned, that's your trigger for when the landlord is allowed to sell or dispose of your home. All right, so what is included in that abandoned property notice? Well, it needs to state that the home was left on the premises and is considered abandoned, that the tenant or any lien holder needs to contact the landlord by a specific date. That specific date needs to be at least 45 days after the date of service of that notice. So either the date that they personally delivered it to you or the date that they put it in the mail. When you contact the landlord, you're contacting them essentially to arrange for the removal or the sale of your home. The notice must state that the home is stored on the rented space, that the tenant or any lien holder may arrange for the removal or sale of home by contacting the landlord at a telephone number or address that is listed on that notice. Again, that needs to be before that specified date in the notice, and that date needs to be at least 45 days after the landlord has sent this notice. The landlord needs to make the home available for removal or sale by the tenant or any lien holder, but they only have to do this by appointment and at reasonable times. So during this period, once you've contacted your landlord does not have to allow you to be on the property all the time. They don't have to let you onto the property for all reasons, right? They do have a duty to essentially store and keep safe your property at this point, and as well as the premises in the park. And their right is to require you to contact them each and every time you need to come onto the rented space to conduct any kind of activity that's either incidental to the sale of the home or to actually physically remove the home. If you're removing the home from the premises, you may need time to remove some of the items that are inside the home. You may need, a contractor to come look at the home and inspect it, make sure that it's safe to move, right? There may be multiple appointments that are required in order to either sell or remove the home from the property. That's okay. But again, each and every one of those times that you're entering the property, that needs to be approved by the landlord. Reasonable times is not defined here, but in other parts of the law, they talk about reasonable times being really in between like 8 a.m. and 6 p.m. So we're kind of thinking like regular business hours here. I do think that it's reasonable, particularly in this type of a circumstance, that there would be appointments after 6 p.m., particularly if you're selling the home, because most people are working during the day, right? And I know when I was looking for a home, we did most of our viewings and showings after work. So I think that that's reasonable as well. Again, reasonable times is not defined here, so it's a flexible term, but just use your common sense with it, right? And try not to abuse it. I think that the most important thing in this process is really having good communication with your landlord. If you are explaining to your landlord, hey, I want to sell my house. I need to replace the floors, repaint the trim and do some lawn work before I want to put it on the market. Can I come Monday, Wednesdays, and Thursdays between X hour and X hour to work on this, during these 45 days. Generally speaking, a landlord's going to be totally okay with that. It's in the landlord's best interest for you to fix that house up and sell that house to a new tenant that's approved by the landlord, and to do that quickly. So if you are desiring to do work on the home, or clean the home, get it ready to go to sell it, I think having good contact with your landlord, explaining your intentions, explaining the work that you're going to do, requesting specific times, and really just being reasonable with your landlord is going to work really in your favor. And most of the time, landlords are more than happy to allow you to come onto the property to do that types of work. Most of the time, the problems arise when the landlord was not notified of the work, or the landlord feels like they're out of the loop, and that the old tenant or the lien holder is taking advantage of their reasonableness and spending more time on the property than they should when they're no longer a tenant and have that right to possession, right? It's important to note that storage fees can be charged, and that abandoned property notice does need to explain that to the tenant. If the tenant moved out prior to the removal by the sheriff, so prior to that order being issued, the landlord may require the payment of storage fees before they release the home to the tenant or the lien holder. However, if the tenant was required to move by the sheriff, meaning that writ of execution was entered and the sheriffs were ordered to remove the tenant, then the landlord can charge the storage fees, but they cannot require that they're paid before the home is removed from the premises or sold, right? If the tenant or the lien holder fails to contact the landlord by that specific date, remember that's 45 days after the personal delivery or mailing, or the tenant fails to actually remove or sell the home within 30 days after contacting the landlord can sell or dispose of the property. So the notice needs to explain that your property will be conclusively considered abandoned if you fail to contact your landlord within those 45 days and tell your landlord that you want to remove or sell your house. Or once you've done that, you fail to actually remove or sell the house within 30 days. You also can agree to a longer date or a different date with your landlord. The law just requires at least 30 days. If one of those two things happen, your property is conclusively considered abandoned, and the landlord can move forward with selling or disposing of your property. Again, here we mentioned before, but the notice also does need to include a note that basically, if your landlord is in a circumstance where they believe that the county assessor will respond to this notice, with a fair market value for your home that is less than, or $8,000 or less, the landlord needs to include that in this notice, basically saying, I believe that your home is worth $8,000 or less. I intend to destroy or dispose of the home should this property end up being conclusively considered abandoned, meaning should you not reclaim your property by selling it or removing it within this abandoned property period, right? So again, this is the contents of the notice that must be sent. This is also a really good overview of kind of the rules and the process of what goes on in an abandoned property process, right? So as we discussed, what will conclusively consider your property abandoned is failing to respond or act, failing to respond to the abandoned property notice, or failing to act to sell or remove your house once you've responded. So let's talk a little bit about responding to that notice. So you need to contact the landlord once you've gotten this notice, either as a lien holder or as a tenant. You need to contact the landlord by the date specified in the abandoned property notice, so again, that 45 days, and express your intent to reclaim your home. Reclaiming your home simply means you're going to remove the home from the premises, or you're going to sell the home to a park-approved buyer. So remember, a huge caveat here when we're talking about selling the home, we're talking about selling the home in accordance with the law and your rental agreement. That is governed by 90.680. It is another complicated statute and not something that we're going to have time to get into today, but is something I'm hoping we'll be holding a presentation on in the future. But it is just important to note that you can't just sell your home to any old Jack and Jill off the street if that person intends to live in that home in the park as a tenant. If the person intends to keep the home on the rented space, that person needs to be approved by your park. You should not complete a sale without your potential buyer being approved by the park. That can get you into all sorts of different issues. So make sure that if you are intending to sell your home during this period, you're selling the home in accordance with your rental agreement and the law. And before you sign on the dotted line, you get that potential buyer approved by the park as a tenant. Once you've contacted the landlord and expressed your intent to reclaim the home, you've got 30 days or an agreed upon date to remove the home from the park or sell the home to a landlord approved buyer. So like we talked about before, you must make an appointment with your landlord to access the home. Your landlord also must make the home available for removal and activities that are incident to the sale at reasonable times. Again, we talked about reasonable times as a flexible standard, and it kind of just depends on what activities are incidental to the sale. If you're talking about fixing something in the home that requires a jackhammer, 7:30 at night is probably not super reasonable, right? Because families are home, families are trying to eat dinner, maybe some kids are going down. It's, kind of noise pollution, right? However, if you are simply having your realtor show the home to some interested buyers, 7:30, 8 p.m. may be a perfectly reasonable time. So again, reasonable is a flexible standard. Use your common sense here. Use communication with your landlord is always to your benefit in terms of getting access to the home and having that go smoothly with your landlord. Like I said, in most cases that I've been involved in, landlords have been much easier to work with, and much more willing to allow tenants to access the rented space when they have good communication about what repairs are being done, what work is going on, why they need access to the space, and actually scheduling times to access the space. when that occurs, landlords tend to be way more willing to be flexible and work with tenants in getting their home sold during this process. Failure to communicate with your landlord other than just these required contacts can definitely lead to a dissolution of the relationship and makes it a lot more likely that a landlord's going to follow the law to the letter rather than being flexible with you and allowing you more time, more access to the home, right, etc. Another important note that you may be required to pay your storage fees before you can remove the home from the park. Generally speaking, if you are selling your home, landlords are going to be okay with the fact that you'll pay those fees out of the proceeds of the sale, but will likely require you to sign some sort of an agreement that entitles them to those fees. Storage fees are outlined in more detail on the next slide, so we'll talk a lot more about them here in a moment. But it's just important to remember that storage fees exist in this situation. They exist even without a storage agreement. Your landlord is entitled to reasonable storage charges for the time that your house is on that rented space. So don't be shocked if you get a bill for storage fees. Now, if you need time to prepare your home for the sale, more than the 45 days the notice allowed you and the 30 days, to actually do stuff, right? Because you can't really access the home until you've contacted your landlord and those 30 days start ticking, right? So if you need more than 30 days to clean, repair, improve, whatever it is that you're trying to do to either sell the home or move the home safely, and you are interested in entering into a storage agreement with your landlord, this is the time that you should request to enter into the storage agreement with your landlord. When we were discussing previously the or agreed upon date, that would be the expiration date of the storage agreement, right? So you would then have until the end. Once you've signed a storage agreement, you would have till the end of the storage agreement to remove or sell your home to a landlord approved buyer, and these same rules apply, right? So during the storage agreement, you would still need to have an appointment with your landlord to access the home, that you can't just be on the home for any willy-nilly reason. They need to be either for maintaining the home or activities incidental to the sale or removal, and storage fees will be due under a storage agreement as well. We'll be talking about storage agreements a lot more later in the presentation, but it is important to note that storage agreements are not everyone has a right to a storage agreement. Only certain tenants and lien holders have the right to essentially force a landlord to enter into the storage agreement, right? So if they say, I want one, the landlord must enter with them. So only certain people have that right. Not everyone has that right. But again, landlords are often willing to work with tenants who are trying to improve the home and sell it. So if you are interested in doing a storage agreement and willing to pay the storage charges each month, this is the time that you're going to want to request that agreement. And, a big fat warning here: if you fail to contact your landlord by the date specified in the notice, or you fail to remove or sell the home within those 30 days of contacting your landlord, or again, that agreed upon date in the storage agreement, your home is conclusively considered abandoned, and your landlord may proceed with the sale or the disposition of your home. So responding to this notice is incredibly important. If you do not respond to this notice, you lose your right to sell the home yourself. The landlord gains that right. And then the landlord may sell the home or dispose of it if they believe that that value is $8,000 or less, and that's been confirmed by the county tax assessor. So again, responding, so important. You're going to lose that right to sell the home yourself if you do not respond to this notice within the time frame. All right, so let's talk a little bit about storage charges. I think this is everyone's least favorite part about the abandoned property process and storage agreements in general is that landlords are entitled to recoup reasonable or actual storage charges and costs incidental to storage or disposal after the delivery of a valid abandoned property notice. So the fees begin to accrue on the date that the notice was either personally delivered or mailed to the tenant. So beginning on the day that the landlord sends that notice, they are now entitled to reasonable or actual storage charges. The storage charge may be up to the same amount previously charged to the tenant for rent, but no more than that rent amount. The landlord can charge for utilities as a storage fee, but only if those fees are, or the utilities are limited to electricity, water, sewer, and natural gas, and only if the use of those utilities is incidental to the storage of the personal property. For example, if you needed to have the electricity, water, sewage on in your home and working in your home, accessing it because you're working on the home and using the electricity, water, and sewer to, assist you in performing the work that you're doing in the home, right? If you're tiling in the kitchen, you're going to be using the water and the sewer for that, right? If you are using a drill or a saw, you're going to be using the electricity for that. Generally speaking, you're going to have a light on and you're using the electricity for that. And so if that is occurring, your landlord can recoup those costs from you. Of course, they cannot recoup more than you are actually using or more than is actually incidental to that storage of the personal property. So when is the payment of these fees due? We know that they start accruing on the first day that notice is sent, after that notice is sent. But when do you have to pay them? Well, if you moved out voluntarily or after an eviction case, but again, before the sheriff was ordered to remove you with that writ of execution, the landlord can require you to pay the fees before they allow you to sell or remove the home. If you moved out after an eviction judgment was entered in against you and the sheriff was ordered to remove you, then your landlord cannot require the payment of these fees before allowing you to sell or remove the home. However, just because they can't require you to pay it before that you sell or remove the home does not mean that you are off the hook for these fees. You owe them, your landlord is entitled to them. They simply cannot essentially hold your house hostage and require payment before they give your house back to you, right? They would have to collect this either through collections, through small claims, through a civil case, through just simply demanding it. There's a lot of different ways that a landlord can attempt to recoup that money. But if you were ordered to, if the sheriff was ordered to remove you after an eviction case, your landlord has to use one of those other methods of collecting that money. They cannot hold your house hostage against you to require those fees. If you've entered into a written storage agreement, then they can't charge you more frequently than monthly, but essentially you're going to be making periodic payments of the storage fee when you're in that written storage agreement. Generally speaking, those charges are due on the first of the month and are very similar to the same process as a rent payment would be made. They're simply not called rent because rent is what tenants pay, and you are not a tenant if you have a storage agreement. So another thing to note here about storage charges is that the landlord only obtains an actual lien against your home for those unpaid storage costs once the home is conclusively considered abandoned. So that means that that your landlord, essentially, when the landlord has a lien against the home for either unpaid storage costs, unpaid rent, whatever it is, when you sell the home, the landlord is legally entitled to be paid out of the proceeds of that sale prior to you getting the proceeds yourself, right? So it ensures that the landlord is going to be able to recoup the charges that they were due when the home is sold. But that lien does not attach to your home until it's conclusively considered abandoned, right? And so until you have either failed to respond to the notice or you failed to remove or sell the property within the allotted time frame, at that point, your home is now conclusively considered abandoned and a lien attaches onto your home for that amount of money. When the landlord goes to sell your home, they again can recoup the funds from that lien in that sale. They can pay themselves out of the proceeds, the amount of that lien. So a landlord sale of abandoned property. So I think hopefully we're clear on when a landlord is allowed to sell your property, and that is when the home is conclusively considered abandoned. The home is conclusively considered abandoned when you fail to respond to the notice or you fail to remove or sell your home within the allotted time period. Once that occurs, your landlord must seek to transfer the ownership record. So they should go to the manufactured home ownership division, fill out the required paperwork, transfer paperwork, get the tax certification, all of that good stuff. The reason that they should do this is because landlords really, when you sell something, you should be the owner of the property. And because your property has been abandoned, you have essentially relinquished ownership to your landlord. You no longer have the right to remove or sell your home. The only right you retain in the home is the right to the remainder of proceeds from the sale. So a landlord must place a notice in the newspaper of general circulation in the county where the home is located. That notice must run in the paper at least once a week for 2 consecutive weeks prior to the sale. The notice must state that the home is abandoned. It must state the tenant's name, the address and the space number where the home is located, the home ID number, or the plate registration or other ID number for a floating home, whether the sale is by private bidding or public auction, when the landlord is accepting sealed bids, and if the landlord is accepting sealed bids, and if so, the last date they will be accepted, and the name and telephone number of the person to contact to inspect the personal property. So this notice, basically, we're going to hold a sale on abandoned property notice. It's got to go in a newspaper that has general circulation, so it can't be like the most obscure newspaper in the planet, right? And that the notice needs to run at least once a week, again, for 2 consecutive weeks prior to the sale. The landlord also needs to provide this notice that they're running in the newspaper. They need to provide that notice to the tenant and any lien holders as well. The notice must be provided a reasonable time prior to the sale. This is because a tenant can participate in that sale. They don't have the right to reclaim their property, but they can purchase it. That notice does have to be sent to the tenant and any lien holder. They need to send it to the tenant either by personal delivery or first-class mail, and to the lien holder by personal delivery or first-class mail, but also with that certificate of mailing. The landlord needs to obtain an affidavit of publication from the newspaper. So essentially, a written letter from the newspaper stating under penalty of perjury that they did run this notice with those contents for at least once a week, 2 consecutive weeks prior to the sale. The landlord also needs to obtain a certificate from the county that property taxes are current, or that the county has authorized the sale with proceeds used to cover the outstanding tax amount. So essentially, if there are outstanding property taxes on your home, the county is allowed to say, yeah, go ahead and sell this property. But again, when the proceeds are being distributed, the proceeds from the sale do need to be used to cover the outstanding tax amount. So let's talk a little bit about the actual sale process. So we just talked about what a landlord needs to do prior to the sale, the notices that they need to publish and distribute, and the information that they need to get. Now let's talk about what happens actually at that sale. So the sale must comply with the notice and publication requirements that we talked about on the last slide. The only exception to this is if you and your landlord and any lien holder have agreed in writing to waive the abandoned property process. There are very few rights under Chapter 90 that you can really waive by a contract. This is one of them. So don't sign that document unless you really mean it. And if you have questions about it, please ask an attorney before you sign it. This is not one of those circumstances where the law will protect you if you sign something that does give up some of your rights, because the law does allow you to waive this process so long as all the parties involved agree in writing. Every aspect of the sale, including the method, manner, time, place, and terms, must be commercially reasonable. Again, reasonable is a really flexible term. Basically, what you would do in this circumstance to determine whether something was reasonable, whether the sale was reasonable, would be to look at other sales that are held in similar circumstances. Look at, and you can take comparables, right? So you can look at houses sold in foreclosure, houses sold on the open market, houses sold in abandoned property, right? There can be different, you can look at different comparables to decide whether or not the sale was commercially reasonable. There's not a strict standard here. Essentially, if the landlord complies with the requirements that we've talked about and the sale is done, at a time that most people can attend, at a place that is accessible, that, the asking price isn't outrageous or so low, whatever it is, right? That so long as that, like, common sense says, okay, this is a reasonable sale, people have access to it, people are able to attend and submit bids, that's going to be commercially reasonable. The proceeds of the sale need to be distributed in a certain order. We're going to talk about that on the next slide. The landlord can purchase the home at the sale. So, so first I'll say the tenant can purchase the home at the sale. A lien holder could purchase the home at the sale. The landlord can purchase the home at the sale, but only if the following circumstances exist. And that is that there is a lien on the home for unpaid property taxes. And essentially that the landlord agrees with the county tax collector that they're going to, after they purchase this home at the sale, they plan to sell the home at an arm's length transaction, which just means someone who's unrelated to you. So, someone you don't know, you're not giving them a super good deal because you love them. You're selling it at an arm's length transaction. You're trying to get the best deal for yourself. You don't really care about you don't really care about the other person. In an arm's length transaction, you're trying to get the best deal for yourself. So they need to send that letter to the tax collector telling them that they're going to sell it in this way, and that they'll follow the section, and that they'll file an affidavit after the sale, not the sale to themselves, right? But after they sell it in that arm's length transaction later on. And that affidavit that they will submit after that arm's length transaction sale to the county assessor needs to state what the sale price was, any of the landlord's claims against that sale price. So, improvements, unpaid rent, storage fees, etc. And then the period of time that it took for the landlord to sell the home. Generally, the landlord in that area would want to be explaining that it took them 6 months because they needed to do X, Y, and Z repairs, weather prevented them from doing it for a few months, yada, yada, right? So they need to explain that the period of time it took to sell the home was reasonable. The reason they need to do this is because each month that the home sits there, the landlord is entitled to that. You know what, actually, I'm not sure if a landlord would be entitled once they've purchased it. That's a great question that I will be doing some research on. But the landlord does have the ability to, make claims against that sale price, including improvements and costs and things like that. And so if it takes longer for the landlord to sell the home, those costs often are higher, which is why the landlord needs to explain this. In this circumstance, the landlord must submit, after the sale, the landlord needs to submit a payment of the outstanding tax amount, or whatever is left from the sale after the landlord's deductions. So essentially, if the landlord wants to purchase the home at this sale, after your property has been conclusively considered abandoned, and your landlord does all the things that they need to do that we talked about on the last slide in terms of noticing and publicizing the sale, the only circumstance in which your landlord is allowed to purchase the home themselves at that sale is in this circumstance where there's an unpaid property tax lien. The landlord is going to fix up the house, sell it again, and that, in the future, that sale price should then be able to cover the outstanding tax amount. So once the sale has occurred, the proceeds from that sale need to be distributed among the lien holders and owners of the property. So this is the order in which the proceeds need to be distributed. First and foremost, the reasonable or actual cost of getting the notice, sending the notice, serving the notice, storing the home, and selling the home. These costs are distributed to the landlord. Any unpaid rent, again, that will be distributed to the landlord. Any outstanding property taxes, that's distributed to the county tax collector. And then any outstanding balance owed on any liens on the home. So if you had a mortgage or another type of lien on your home, the outstanding balance of that loan would be distributed out of the proceeds to the lien holder. And if there are any remaining proceeds of the sale, that needs to be distributed to the tenant. The tenant should also receive from the landlord an itemized accounting of all of the things that were deducted from the proceeds and who they were distributed to. A small note here that if the current market value of your home is $8,000 or less, and the proceeds are insufficient to cover the outstanding tax amount after covering the landlord's expenses, the county is just going to go ahead and cancel all of your outstanding taxes and special assessments in that situation. If the tenant cannot be found in order to give them that itemized accounting and the remaining proceeds, the landlord needs to deposit the remaining proceeds with the county treasurer. The county, as a tenant then, or the owner, lien holder, you have 3 years to claim the proceeds from the county treasurer. If you don't claim it within those 3 years, then those proceeds will revert to the county's general fund, and the county can use those funds for general purposes. So what happens if your landlord decides to dispose or destroy your abandoned property? So they're allowed to dispose of or destroy your home only if the county assessor states that the current market value of your home is $8,000 or less, or there is no buyer at a valid sale. So that means that your landlord complied with all of the requirements that we just talked about prior to the sale, during the sale, and that at the sale, there was no buyer. If there's no buyer at the sale, after the landlord has complied and done a valid legal sale under the law, basically what the law says is that we presume that your home is $8,000 or less in fair market value. And we allow your landlord to go ahead and, conclusively consider your home abandoned and go ahead and destroy or dispose of your property. So your landlord is also allowed to destroy or dispose of your property if you and your landlord agree in writing after termination or no more than 7 days prior to termination of your tenancy, along with any lien holder to the property that you want to waive your right to the abandoned property process. Again, this is one of those scenarios where waiver, where you can waive out of your rights by contracting with your landlord. Most of the time, a contract with your landlord will not waive those rights under the law. This is one of those rare circumstances where it really does, where you can contract out of the right to the abandoned property process. You just simply need all of the parties involved to agree to that in writing. So if you get a waiver of abandoned property, review it very carefully, be skeptical of that, understand what that means. It does mean that the landlord does not have to decide your home is $8,000 or less in current market value in order to destroy or dispose of it, right? They don't have to follow any of these rules regarding the process for abandoned property if you sign that waiver. So be sure that that waiver is something you want to agree to before you sign it. If your home is destroyed or disposed of, the county tax collector will cancel all the unpaid property taxes and special assessments that were entered against the home. That makes sense. They're entered against the home as a piece of personal property. That piece of personal property no longer exists. So we should not be collecting property taxes on things that do not exist. So what happens if your landlord violates this process? And this obviously applies only to circumstances where you have not signed a waiver of abandoned property process, right? If you've signed a waiver, your landlord doesn't have to follow this process. So a violation of this process is irrelevant. So we're talking about a circumstance in which the abandoned property process applies. You have not waived out of it. And the landlord has violated that process. So the law is relatively protective of your landlord in this circumstance. The law states that your landlord is not responsible for any loss to the tenant or the lien holder that results from the storage of the home, so long as the landlord has complied with ORS 90.675. Compliance with 90.675 is good faith compliance with that statute, with the legal requirements, is a total defense to an action for loss or damage of the home. That means that if a landlord did everything that they could, they did their very best to send out the notices to every single person, that they did their due diligence to try and find your new address. They sent the notice to all of the places that are required. There were no blatant, deliberate, or negligent reasons for why this loss was caused. Then your landlord's basically off the hook, right? So as long as, again, they've complied in good faith with these legal requirements, there is really no claim for any of that loss or damage that results from a violation. However, if the landlord was deliberate or negligent in in the violation, right? Or in the action that caused the loss or the damage to the home, then the landlord is liable in that circumstance. And that would be for twice the actual damages sustained. What I can think of in this circumstance often is the sending of notices and addresses that the landlord has access to. So if the loss was caused because you did not receive an abandoned property notice because you did not provide your landlord with a forwarding address, your address on the homeowner, your homeownership document is the property address, right? That the landlord has no real way to reach you, and they send the notices to the actual home, the property, but you're not checking that mail, right? And you didn't get the notice because the landlord does not know of a forwarding address for you. And the record of your homeownership document doesn't show a different address other than the rented space, right? And so that's why you didn't get the notice. Well, the landlord has a defense to that because they complied in good faith with the legal requirements in that situation when they attempted to send the notice to all of the addresses that they had for the tenant, including the rented space. But simply those addresses were either not correct or there was no forwarding address. That's not the landlord's fault. That's not negligence. That's not deliberate. And so the landlord would have a complete defense to that, even though you may have lost your ability to sell the home. The landlord may have sold the home for you. The landlord may have determined that it was less than $8,000 and destroyed your home. As long as they complied, again, in good faith, they've got that complete defense. When we're talking about something deliberate or negligent, we're talking about a situation where, say, you knew you were going to be moving out, that this process would occur. You provide your landlord with a forwarding address, and your landlord loses it, right? Or your landlord fails to send the notice to that forwarding address after you've provided it to your landlord. I think that you could argue that that was negligent or perhaps even deliberate. And I think you could then in that circumstance argue that you're entitled to damages, right? So again, this good faith requirement, good faith compliance is not complete compliance. It's not exact compliance. It is doing everything that the statute says to the best of your ability. And most of the time the statute even says like if the landlord knows of it, right? So again, the rights here, the damages here are not super strong for tenants. And this is part of the reason why in previous slides, I put a big red box that says important note, provide your landlord with a forwarding address, right? You want to try and cover your butt in as many ways as you can when you're dealing with your landlord, particularly when you're dealing with complicated processes like this. Give your landlord everything that they need to get you the information that you need, right? If you've provided your landlord with a forwarding address, a PO box, an email address, whatever it is, right? You've provided them with all of this contact information and they still fail to send you the notice. I think you've got a pretty good claim right there. So by providing them with this information yourself, by sending it in an email, by sending it by certified mail, right? By creating a record that you've provided your landlord with this information, you're setting yourself up in a much better way for should something terrible happen and losses are caused, that you've got a record of what occurred, when it occurred, what your landlord knew, and when, which will really help either yourself or an attorney, determine whether you've got a claim and actually prove that claim in court and get you some of those damages, right? So keeping a good record and making sure that you've provided your landlord with the things that they need so that you actually get the information to protect yourself, that's really important. And it's something that you can do as a tenant that is relatively easy, low stakes, low risk, and quick. Takes no time at all to send that contact information, and can really save you in the end. So it's a kind of quick and dirty trick to make sure that that your landlord knows how to get a hold of you and that you're getting the information that you need after your tenancy has terminated. So if the landlord has violated the abandoned property requirements, the tenant or the lien holder is entitled to two things. One, waiver of any unpaid rent and the cost of the damage to the premises, and twice the actual damages sustained. So, you know, there are damages that are available, right? When these types of violations occur, but again, it isn't, you know, it's not a strict violation type claim. There is, you know, there is that defense, that good faith compliance defense that is a total defense for the loss or damage. So you really are going to in here need to prove that an actual violation occurred, right? So that the landlord did have your forwarding address and failed to send it to you as the statute requires, right? So you do have to be able to prove that an actual violation occurred, and not just that the landlord didn't have the information, or you know, a snowstorm happened and leaks happened, whatever the damage was, right? In order to get these types of damages, in order to sue for these types of violations, you do have to prove that you know, the abandoned property statutes require something of your landlord and that your landlord failed to do that thing. All right, so let's talk about storage agreements. So storage agreements. A storage agreement is a written agreement with your landlord, and it allows you to store the home on the rented space in exchange for a storage fee. And the storage agreement will set forth any additional terms and conditions of the agreement. Important to note that a storage agreement does not give you the right to possess the home. Again, we are out of tenant land, we are out of possession land, we are in the right to sell and remove your homeland. The right to possession has now reverted to your landlord. You do not hold it anymore, and you do not hold it under a storage agreement either. So the purpose and the scope of a storage agreement, just 1 second, sorry. So you do not have a right to possess the home under a storage agreement. You cannot reside in the home under a storage agreement. No one else can reside in the home under the storage agreement. You need to get your landlord's approval to come onto the property, to be in the home, to maintain the home. Any of those things, you need your landlord's permission to do so. Again, which is why I recommend having good communication, laying out timelines, and setting specific dates and timeframes where you may be at the home conducting work, and letting your landlord know that at the beginning of the agreement, because you do not possess the right. You do not have the right to possess the home, and you need that permission from your landlord to be there. Having good communication with them throughout the life of the storage agreement is super important. So the purpose of a storage agreement is to provide the holder of that agreement with time to sell, remove, or dispose of the home. The landlord is not allowed to sell or dispose of the home during that agreement, during the term of the agreement. However, you are allowed, the holder of the agreement is allowed to sell or remove the home during the agreement. If the holder fails to sell or remove the home when the agreement expires or terminates, your home is considered conclusively abandoned and your landlord may sell or dispose of your property. So a storage agreement essentially extends that abandoned property period from 30 days to the length of the storage agreement. The storage agreement can contain additional requirements, such as maintaining the home and space, following park rules, etc. Right? So there can be additional terms in that agreement. We'll talk a little bit about what those terms may be, but it's important to note here that when the agreement, so the agreement can either expire, meaning that you reach the end of the term of the agreement. Say the agreement was for 6 months. You've reached the end of that 6 months. You've not sold or disposed of your home, sold or removed of your home. Well, now your property is considered conclusively abandoned. And then we go back up to that abandoned property process when we're talking about the sale of your home, the landlord sale of your home, right? So essentially the storage agreement extends that 30 days of the abandoned property process where you have the chance to remove or sell your home. It extends that for a longer period of time, but the consequences of failing to sell or remove your home within the time frame are the same, right? The consequence is that if you fail to remove or sell your home in that time frame, your landlord is going to be able to sell or dispose of your home on your behalf and can recoup their costs when they do so. So the contents of a storage agreement. Storage agreements, obviously, they're going to say you can store your home on this rented space, but you have no right to possession. Every storage agreement says that. A storage agreement cannot give a right to possession because only tenants have a right to possession in this type of situation. So the other terms that are going to be in there is that you'll have a periodic due date for your storage charges. The storage agreement will also set forth the amount of those storage charges. The storage charges cannot be due more frequently than once a month. The landlord is allowed to charge late fees, but those late fees cannot be any greater than the late fees that the landlord charges for regular tenants if they fail to pay their rent on time. And all of this should be stated in the rental or in the storage agreement clearly so that the holder of the storage agreement understands their obligations, how much they need to be paying each month, if utilities will be included, or how often they'll be paying, right? I assume it's each month. Usually it is in my experience, but again, amount, frequency, due date, whether there's late fees, how much the late fees are. There's also most of these storage agreements contain a requirement to maintain the home and the rented space according to park rules and to comply with all park rules and regulations. The requirement to maintain your home and the rented space obviously necessitates you to come onto the property to conduct that work. But again, in a storage agreement, you don't have the right to possession. So you need to get your landlord's approval before you can come onto the home to conduct those activities. Your storage agreement may set forth days and timeframes in which that work can be completed without prior approval from your landlord. If your storage agreement is silent on when and how you can come onto the property to maintain the home and the space, then you do need to have a conversation with your landlord about when and where and how that maintenance work is going to be conducted, by whom, at what times, and get their permission. Often these storage agreements will contain a requirement that the holder of the agreement repair any defects in the physical condition of the home. The holder of the agreement has 90 days after entering into that storage agreement to make those repairs. And the landlord can issue a 14-day basically repair or terminate notice if the repairs are not completed in that 90-day period. That termination notice essentially gives you 14 more days to do the repairs, or the storage agreement terminates. And again, remember, upon termination of the storage agreement, your property is conclusively considered abandoned. It reverts to your landlord, and they are allowed to sell or dispose of that property. Again, we just talked about this briefly, but the termination of the storage agreement. So a storage agreement may be for up to 12 months, right? But if you violate your storage agreement, either by failing to do repairs, if you violate park rules, if you fail to maintain the home, if you fail to pay your storage charges on time, or just fail to pay them at all, right? These are all things that your landlord can issue a termination notice for. The landlord can do the first time you violate the storage agreement, you get a 90-day written notice of the violation, and you're allowed to, and then you have that 90 days to cure the violation. Essentially, if you don't cure the violation, so fix it within those 90 days, then the storage agreement will terminate at the end of that notice period. The landlord also has the option to give you a 30-day written notice if you have repeatedly failed to pay your storage fee. And so that means that the landlord previously gave you a 90-day written notice for violating the storage agreement for failing to pay the fee, that you paid the fee during that 90 days. So you cured the notice, you kept your storage agreement, it did not terminate. But then you fail again to pay your storage fee. This time around, your landlord is only required to give you 30 days written notice of the violation, and your storage agreement will terminate at the end of those 30 days only if you don't pay that amount during that 30-day period. If something occurs where you are threatening, where a tenant, or excuse me, a storage agreement holder is somehow threatening the health, safety of other tenants, they may be removed for, your storage agreement may be terminated under that as well. And in that circumstance, your landlord's not going to have to give you that full 90 days an opportunity to fix it, if the violation is severe enough. So, be respectful out there. If you've got a storage agreement, I know sometimes it's tough with, relationships with neighbors can be tough. There can be, lingering issues with prior neighbors or other tenants in the park. And I know that it can be tempting to engage with them when you no longer live there, but you see them because you've come onto the property to do some sort of a work. But do be careful with with how you talk to people in the park, with how you interact with management. Just because you don't have a rental agreement and you're not a tenant does not mean you can't be terminated under that storage agreement for those kinds of similar types of antagonistic behavior. And again, if your storage agreement is terminated, then your property is conclusively considered abandoned. That means that your landlord can now proceed with selling or disposing of your home. And remember, we looked at the distribution of proceeds from the sale of the home, and a lot of money is going out to other parties before it ever comes to you. Whereas if you are to sell your home, only those people with recorded liens are entitled to the proceeds of your home, or entitled to take from the proceeds of your home before it comes to you. So you definitely benefit financially from holding your own sale, from selling your own home, versus having your landlord sell your home under this abandoned property process, because your landlord is entitled to recoup those storage fees any unpaid rent, and, you know, any of the costs that were related to the sale. And so the landlord really can recoup quite a bit of funds. And they also don't have a huge incentive, right, to hold out, wait for the best buyer. You know, they're required to place an ad for 2 weeks and to hold a sale, and that's all that they're required to do for the sale, right? So you know, a landlord's really motivated to, or there's an incentive for a landlord to get the sale price at least as high as as what they plan to deduct from the sale price, right? So that they can be made whole. But beyond that amount, the landlord really doesn't have an incentive to seek out the highest price. Um, and as long as they're following what the law requires with, you know, publicizing the sale for 2 weeks following or prior to the sale, and they hold a sale in a commercially reasonable manner, that's all they're required to do. So it really is in your benefit to sell the home yourself. Um, even though you're basically having to pay the same amount every month as you would for rent, and you're not allowed to possess the home. If you do believe that your home has value, that you can sell that home, and you can even find estimated values like on Zillow. You can literally just search in your exact address on a website like Zillow, and it'll give you their Zestimate, right? I mean, that's not a legally binding number by any means, but it can give you somewhat of an idea of what your house may go for. And you know, there's a significant benefit to selling your house on your own, because a lot of those funds are not going to be coming right off the top of the sale price. That's going to be going to you. And then you can either, you know, pay things out to your landlord yourself. You can fight about those things with your landlord in small claims, or, you know, force them to send it to creditors, whatever it is, right? But they don't have that legal right to deduct their own costs from the sale price, right? If you sell it yourself, they don't have that right unless they're a registered lien holder. So it really is in your benefit to enter into a storage agreement, to follow the terms of that agreement, and to do your best to sell your home on your own, or with the assistance of a realtor, but essentially, you know, not allowing the landlord to sell it in the abandoned property process. If you can avoid that, you're going to make a lot more money off of your sale. All right. So as I mentioned before, there are certain people who are entitled to a storage agreement. And these are the following people who, are entitled to a storage agreement. Lien holders, the personal representative of a deceased sole tenant, and marina tenants. So lien holders have the right to enter into a storage agreement with the landlord only if the tenant or the personal representative fails to reclaim or sell the property within the allotted time. So that means that if the tenant or personal representative contacts the landlord within the 45-day abandon notice period and requests, and enters into a storage agreement with the landlord, then the lien holder then in that situation does not have a right to the storage agreement, because it's already been given to someone else, right? You think about like the tenant and the personal representative, they're your tier 1 people. They're the people most entitled to sell the property. Lien holders are secondly entitled. So if the people in that first line, right, so the tenant or the personal representative, if they fail to do what they need to do to either sell, reclaim the property, or enter into a storage agreement, now that right falls down to the second tier of people, who are the lien holders. So again, this right only kicks in if the first tier of people fail to exercise their right, and the first tier again is the tenant or the personal representative of the deceased tenant. The landlord is required to enter into a storage agreement with a lien holder in this specific scenario when the when the lien holder requests it from the landlord. The lien holder must sign the storage agreement provided by the landlord within 60 days of receipt in order to preserve this right. So if the landlord provides them with a storage agreement and they fail to sign it for 2.5 months, they no longer are entitled to that storage agreement. The law allows for this agreement to be up to 12 months. There is not a minimum. For the personal representative of a deceased sole tenant, and you can find more information in subsection 20 of the statute. So the personal representative of a deceased sole tenant, this means that the tenant owner lived in the home, they died, they were the only tenant owner, the only tenant of the home, they've passed away, and the property is now in the abandoned property process solely because the tenant owner died, right? So their personal representative, so the person that is representing their estate in probate, or someone who has been designated by the tenant and identified to the landlord, so it can be the personal representative or that identified person, they would be in receipt of the abandoned property notice and would need to contact the landlord within the 45-day notice period and request to enter into a storage agreement with the landlord. The landlord is required to enter into a storage agreement with the personal representative if requested, and the length of the agreement is up to 90 days or the conclusion of probate proceedings, whichever is later. And more information about the death of a sole tenant and how that abandoned property process works is found in subsection 21. And the last group of people who are entitled to storage agreements are marina tenants. Marina tenants must contact the landlord within 45 days of the abandoned property notice and a request to enter into the storage agreement. The landlord's required to enter into the storage agreement. Marina tenants must sign the storage agreement provided by the landlord within 60 days of receipt, and the length of agreement is for up to 12 months. And more information about that can be found in subsection 22. So in a written note, you'll notice here that the one main group we're missing is facility tenants. There is no requirement for a landlord to enter into a storage agreement with a facility tenant. However, landlords often enter them all the time, right? So there are benefits for a landlord to enter into a storage agreement, particularly when the tenant owner wants to conduct some repairs or improvements prior to putting the home up for sale. Nicer homes, improvements, all of that benefits the landlord and their business. And so oftentimes they are going to be willing to work with facility tenants to create some kind of a storage agreement that will work for their situation. If you're interested and you're in a storage agreement and you have the money to pay, again, remember, you're basically having to pay the same amount that you would for rent every single month, but you cannot possess the home, you cannot live there. So it is expensive to do this, but if you are able to afford it in a short-term scenario, it really can be a benefit to you. If you believe that you can get your home sold, entering into a storage agreement is a great way to get the improvements done, make sure that you have enough time to get the sale done, to get the potential buyer approved. And in the long run, you're going to end up making a lot more money off of that sale than you would allowing your landlord to sell it through the abandoned property process. All right, and so that's all I've got for you today. It was certainly a lot. Like I said, this area of law is not simple. It's a bit complicated. It's complicated for both tenants and landlords, and and again, there's a lot of context that goes around this, like how the requirements for the sale of a home and and discussing the differences between lien holders and tenants. There's just a lot that goes into understanding this specific area of the law. And I'm happy to answer any questions that might help reveal some of this mystery for you. I'm not sure we have very many people in the meeting to ask questions, but in that case, that is totally fine. I just want to put a plug here that if you visit OregonLawHelp.org, you can find more information about local legal aid offices. There is an interactive map there that allows you to find the office for your particular county. It provides contact information there as well. That website also has a ton of resources for tenants, and I just highly recommend taking a look at it. My hope is that I will get some updated abandoned property material posted on our websites soon. My goal is within the first 6 months of 2024, I'd like to get at least 3 to 4 topics completely covered with the resources. So that is the goal. Keep on looking out at Oregon Law Help and MMCRC and OSTA for more information.